This blacklisting order was issued without issuing any so-called notice.
Let us see the order first. Where is the order?
Page number 133 to 142.
133,
Your Lordship.
Now, at page 136 we find that there is something called final show cause.
I want
Failure to meet performance standards on various. Just a minute. Has it been quoted in the order? Let us see.
Second.
You have not received any notice of proposed action of blacklisting.
Actually, Your Lordship, I want to give a...
Say yes or no. Say yes or no. Did you receive any specific notice for intimating you that that if you don't satisfy, your firm may be blacklisted?
Your Lordship, I didn't receive any notice from competent authority or party to the contract.
Yes, what's your response to this, Mr. Vikas Kumar?
My lord, 2 words before that. The matter was heard yesterday, and I was asked that they are not. We have no contract between the petitioner and the statements. So on that, our judgment, it is against us, but it can be distinguished.
Which judgment is against you?
My lord said 2021. Page 339, 2021, 11 SCC 339.
What's the name of the case?
It is
We might remember.
It is Medipore Pharmaceuticals India Private Limited.
Can we have a look at it?
My lords have reported this.
I have referred this. But many a times we forget.
Not in so way it is against us, because in that case no contract was entered between the parties, even though they have participated in the tenders. And
Just
before execution of
give us 2 minutes.
Case, please.
Yes, that's all right. This is the principle of blacklisting which has been repeated.
Yes.
But there is
and
nothing.
Ultimately, the question will rise that whether we can take action of blacklisting against the petitioner or not.
Forget about contract or anything of that kind. Yes. Have you given him a notice?
Yes.
Where is that?
Very specific notice.
Where is that notice?
Well, it is 4/5/2022, annexure P/8.
In your contract?
No. It is in the writ application itself.
P/8?
Page 111. By this order, by this publication, we have blacklisted the petitioner as disciplining him, and the show cause notice with respect to termination and blacklisting for 3 years. cannot be termed as blacklisting, rather debarment from participation in the.
No, debarment has the same. This is
Yes.
also one of the methods of disciplining.
Yes, and it is with respect to participation of.
Where is the notice?
Malas, it is 111. Malas, may kindly appreciate.
Annexure P8.
P8, and
We'll ask Mr. Vikas Kumar to appreciate that we are looking for the notice. This is office memorandum.
Malas,
It in general talks about so many things.
Malas may come at page 115.
I'm not understanding. Yes.
Last paragraph.
Yes.
Hence, therefore, the department, in furtherance of the repetitive non-compliance in meeting the timeline of the deployment, upgradation and existing IT infrastructure, including installation of server failure, the vendor is directed to take up.
This is a decision.
Malas, may come. Malas, bear with me. What? 1 or 2 minutes.
That's all right. You read.
The vendor is directed to take up the above mentioned issues regarding the poor management of IAMS and call center with the panel agency. We have been introduced by the vendor Kionix as impaneled agency and resolve the pending issues to the satisfaction of this department within 13 days. The vendor may consider changing the impaneled agency if it is not able to redress the grievance of the department. However, if the vendor chooses to change the impaneled agency, the vendor should ensure that the transition is smooth and without any disruption of the IMS of the call center operation.
So therefore come to B now. Vendor and the impanel agency are also directed to submit a reply within 30 days as to why the contract did not finally terminate.
Yes.
And we will refer to it. This is no notice in the eyes of law.
Malas,
This is not a notice which is
have,
contemplated.
Malas, they have replied to it. They have replied to
Let
it.
them reply. The reply may not be appropriate because you have not formulated. You have to say that this is the charge against you. Now, not in exact words that I am saying. The noticee must understand what is the charge against him, and if he doesn't satisfy, he will be blacklisted. It's a vague notice.
No, it is not mine.
Your Lordship.
Malas, I may be permitted to read Malas from C, D, and it till such time as the panel agency takes to resolve the above mentioned grievances relating to IMS and call center.
All right, this is your argument.
Malas, this is the notice in terms of for blacklisting the impanel because it has been addressed to Datacon as well as the Kionix panels.
Try and understand, let the bench and the bar both evolve and improve upon the understanding. Now, merely because you say that you would be blacklisted, it would not be construed as a notice. Now, try and remove yourself, Mr. Vikas Kumar. Look at the bench. But don't be fixated on the printed lines. When the court is asking you to understand, it's also in the process deliberating. Where is the confusion and why you are not removing yourself from the slated position that you have come with. Now, this is something now we have to understand it in a different way. Now, you have read Pulja, you have read Wet India, you have read Daffodils, you have read Eurasian. One judgment that you have cited to us that takes care of all these precedents. Now, blacklisting and debarment have very, very serious consequences. Now, therefore, the notice has to be very correct. Now, the moment we read subclause D of this paragraph that you are trying to read, if the impanel agency removes the grievance of the department before 30 days, the department may consider removing the impanel agency from the blacklist at an early date. Therefore, by this notice, you are giving them an opportunity to improve upon their work, to complete the work. And should it not, if the work is not completed, then perhaps the decision to blacklist, for that a notice is required. And if you are not understanding, repeatedly let us pass the orders. Now, on this ground only we will set it aside, ask you to take a further decision. That's right. Now, we will spell it out. Not that you have not communicated. Now, you have come with a position that this is the information given. Now, this is again a decision which has been taken. 30 days of blacklisting and the notice prior. The vendor and Simpan may consider this 30 days blacklisting memorandum as the notice prior to final termination. This is no notice.
Termination followed by blacklisting for a
That is not the way in which notice for blacklisting is to be given. He doesn't know. He only thinks that an agency If these things are done, perhaps the contract would subsist. See, it's very simple. Not that if they have not been able to do your work properly, you are fully justified to terminate the contract.
We have suffered a lot.
You have, and put them to liquidated damages. There's no difficulty.
Even the court management, they are required to.
We are aware of this. Now,
the
Mr.
court
Vikas,
proceeding is stalled, my lord.
Your
Try
Lordship,
and
we have done
And
everything.
all at the cost of us, they have developed 13 models.
are we supposed to enter into all this?
I'm sorry.
The difficulty is that we are testing the order on the parameters of law which has been set. Right? You also cannot breach that. The party cannot take advantage. If I set aside this order of blacklisting for 3 years and debarment or whatever, I think we will be fixing a time within 3 months. Give them the notice, they must reply, and then you can take a positive decision with respect to putting them to damages also. Where is the difficulty? We have no sympathies for such kind of dealers. But not a notice like this. Now look at this. You have treated this notice. Now where is the order? Where is the order of blacklisting? If there is no order for blacklisting, then perhaps he doesn't have a forum to agitate now. This is notice. All right, we have followed. Where is the order? Show us the order.
Page 133.
Page 1?
33 blacklisting order.
141 is the operative portion.
133.
133 to 142.
There's a clarity.
133 to 142.
133.
Sir.
So there are two cases, Lord. One is Datacom.
And you're for Kionics.
Yes, Lord. I am for Karnataka. The SOCOS is the same, Lord, but only.
We will deal with Kionics later. First, let us deal with
Let us represent the statement in Kyoto.
That's right. We'll hear you later. Now, these observations would be true for you also, but you have a better standing so far as the state is concerned. Because you have entered into an agreement with Kionics.
Yes, and
so
there is
therefore,
a clause
your
of agreement, Lord, and under the strength of that clause only.
That's right, Mr. Vivek Prashad. Your efforts, I mean, you require lesser efforts to sustain. But he perhaps
He is better prepared.
No, you would require lesser efforts. He would require more efforts.
Yes,
All right.
sufficient.
बहस करिए आपके पास इतना बड़ा पॉइंट है उसको बहस नहीं करेंगे केवल कोर्ट पर डिपेंड करेंगे कि कोर्ट सब पॉइंट खोज के आपको दे तो अच्छा नहीं है ना
Your Lordship,
आप
actually,
एक लाइन पढ़िए फर्दर डेवलपमेंट्स दीज डेवलपमेंट्स वर नॉट इन कॉन्टेम्पलेशन दैट दिस वाज द चार्ज उसके आगे पढ़िए सब्सिक्वेंट डेवलपमेंट्स कंफर्म द एप्रीहेंशन नाउ ऑन समथिंग व्हिच हैज हैपेंड लेटर देन नोटिस दे हैव ब्लैकलिस्टेड यू ये ग्राउंड नहीं बोलेंगे देखिए
that's why we are saying that we don't have any notice from the.
We are ready.
टेक डन हर्ड मिस्टर क्या नाम है आपका
Kumar Amit.
heard Mr. Kumar Amit for the petitioner and Mr. Vikas Kumar for the state. The petitioner
May I, Your Lordship, actually we completed the project and we got the go-live certificate also from the department. There was some issue pertaining to payment and because of that only we have been blacklisted. And there was the clause for arbitration.
Just a minute. क्या लिखा है? How have I begun?
Heard Mr. Kumar Amit for the petitioner and Mr. Vikas Kumar for the state the petitioner.
The petitioner / Datacon Technologies Private Limited has challenged the order dated 4/5/2022 issued by the Deputy Commissioner cum Nodal Officer Prohibition, Excise and Registration Department of Government of Bihar, blacklisting the firm initially for a period of 1 month and thereafter by order dated 3/6/2022, by which the petitioner has been blacklisted for 3 years. The major grievance of the petitioner is that no show cause notice was served upon the petitioner before taking the decision of blacklisting it for 3 years. The petitioner / Datacon Technologies Private Limited was impaneled by Karnataka State Electronics Development Corporation Limited, bracket hereinafter called Kionix, a government of Karnataka enterprise, to undertake the implementation of the IEMS and call center project of the state of Bihar. The Department of Prohibition, Excise and Registration, Government of Bihar, had issued tender for selection of an agency for design, supply, installation, commissioning, operations and maintenance for Integrated Excise Management System, bracket में लिखिएगा IEMS, for the department. In the aforesaid tender, Kionix was selected as the total solution and service provider to undertake the project of development and implementation of the solution, its rollout and sustained operations. Next, a master service agreement was entered into between Kionix and Bihar State Beverage Corporation Limited. So, under the aforesaid agreement, the petitioner was empaneled to undertake the entire implementation work as noted above. It is the case of the petitioner that under the master service agreement, which contained detailed provisions for dispute resolution, including that of escalation, conciliation, mediation, and arbitration, which could have been invoked in cases of complaint. How have I begun? What is the sentence beginning?
Under the aforesaid agreement, the petitioner was empaneled to undertake the entire implementation work.
That's right.
As noted above, it is the case of the petitioner that under the master service agreement, which contained detailed provisions for dispute resolution.
But the respondent chose to blacklist the petitioner, with which there was no direct agreement. So the petitioner had been working under the master service agreement, which was concluded between Kionics and the department of the government and the concerned department of the government. For their part, the petitioner has informed this court that the obstacles and grievances, the obstacles in the way of completion of the project were made known to the government, were made known to the department through the vendor, namely Kionics. There were issues of unavailability of infrastructure, non-functional internet facilities at checkposts, and delayed payment of services rendered. But no heed was paid to such complaints. The further grievance of the petitioner is that the department chose to change its requirements, which was conveyed to the petitioner, but those changes were not part of the master service agreement. Because of all these bottlenecks, there was some delay in execution of the project. Notwithstanding the petitioner having moved the entire hardware items to Patna in August 2017, the implementation work could not start till 2019 for want of unanimity of location for carrying out the work. The major grievance, as noted above, the major grievance of the petitioner, as noted above, is that by office memorandum dated 4/5/2022, the vendor / Kionics and the petitioner were informed that the department was of the view that the delay in making the project go live was because of non-implementation of various modules of IEMS software and its poor management By the aforementioned notice, it was declared by the department that the vendor would be obligated to take up the issues regarding poor management of IEMS and call centers with its impaneled agency, that is the petitioner, and resolve the pending disputes, resolve the pending issues to the satisfaction of the department within 30 days. Within 30 days. The vendor was even given the liberty to consider changing the impaneled agency if it was not able to address the grievances of the department. It was also cautioned that in case the impaneled agency was changed and substituted by another, the transition ought to be smooth without disrupting either the IEMS or the call center operations. Along with this declaration, the vendor and the impaneled agency, that is the petitioner, were directed to submit a reply as to why the contract be not finally terminated and the vendor and the impaneled agency be blacklisted for a period of 3 years. For a period of 3 years. Till the time the impaneled agency resolves the disputes till the time the impaneled agency resolved the dispute, the petitioner was blacklisted for a period of 30 days with immediate effect, prohibiting it, till further orders, to participate in any future project of Prohibition, Excise and Registration Department in any direct, indirect or subsidiary capacity. This blacklisting, this provisional / tentative blacklisting, however, was with a caveat that if the grievances of the department would be addressed before 30 days, the department may consider removing the impaneled agency from the blacklist at an early date. The office memorandum referred to above further indicated that if the services provided by the vendor and the impaneled agency did not improve or addressed the grievances, the department would mull over the termination of the contract by invoking clause 18.1.1 of the agreement with all its necessary consequences. There was also a veiled threat in the aforesaid office memorandum that the department would not renew its master service agreement with the vendor unless there was improvement in the management of IEMS and call centers. The department could take a sympathetic view and consider removing part of the penalty. Consider sympathetic view and consider continuing with the vendor and the impaneled agency. Mr. Kumar Amit, learned advocate for the petitioner, submits that this is no notice for blacklisting for two reasons. The tenor of the office memorandum only reflects the grievance of the department and an opportunity to the vendor and the impaneled agency to address those issues and sort it out. Failing which there could be termination of contract with the vendor and there could be blacklisting of the vendor as also the impaneled agency. And secondly, that blacklisting as such was not in the contemplation of the petitioner when it received such notice. For the major thrust of the intimation was improving the working of IEMS and call centers. The notice would have been complete only if the department would have said that nothing has been done within the time frame entitling it to invoke the provision of blacklisting and debarment as also termination of contract. It has further been submitted on behalf of the petitioner that blacklisting entails very serious consequences. And it takes out a company from the privilege and advantage of entering into any lawful relationship with the government for the purposes of gains. With an action so stringent, with such cascading evil effects, notice is a must, as it is one of the primary requirements of principles of natural justice. Notice must intimate the noticee. The contemplation of the department in view of deficiency in the service provided to blacklist it. The notice cannot be tentative, vague, or giving various options to the noticee. On a plain reading of the notice, on a plain reading of the purported notice, the petitioner thought it to be a reminder that the services at IEMS and call center ought to be improved or upscaled, giving liberty to the petitioner to further indicate the impediments faced by the impaneled agency or the vendor, which could in turn have been addressed by the department. Stop. This office memorandum, comma, the learned advocate submits, prima facie appears to be a deliberation of one party with the other, and not a notice as desired for as serious an action as blacklisting. The order of blacklisting dated 3/6/2022 refers to the same grievance of the department, namely poor management of IEMS and call centers, including certain new aberrations in the carrying out and implementing these schemes. There is reference of another show cause notice having been issued by the department to the main vendor / Kionics regarding supposed default in deduction and contribution of EPF amount and ESI of employees of the petitioner who were engaged with IEMS. First up, the sudden and complete shutdown of servers, for which the empaneled agency could not have been squarely held responsible, on 31st of May 2022, an event which happened later than the notice was also, yes?
Yes, initial C at page 22 of counter affidavit. We have asked the Kionics to inform that for smooth functioning of this, we have also, it was not served to the petitioner, but we have informed that to.
We are on the contents of it. It's no notice. All right, we will take note of it. Kalika, try and understand what the court is hinting at. It's not on that. Yes.
The sudden and complete shutdown of servers for which the impaneled agency could not have been squarely held to be responsible on 31/5/2021, an event which
क्या लिख रहे हो? फिर से पढ़ो.
the sudden and
the sudden and complete shutdown of servers on 31st of May 2022, an event which occurred post notice, was also taken into account for blacklisting the petitioner, as such shutdown of servers affected IEMS supply chain module, leading to total collapse of the call centers. This was an isolated, separate event for which no notice, for which the petitioner had no notice that this event shall be read squarely against the petitioner for blacklisting him. It further appears from the order of blacklisting is that there was no response two such notice by Kionics and the petitioner, the impaneled agency communicated with Kionics, revealing its decision to withdraw from the project from 20th of May 2022, which was communicated to the department on 19th of May 2022. This unilateral withdrawal from the work with only 24 hours notice to the department also appears to be one of the reasons for blacklisting the petitioner. The Land Council for the petitioner after taking this court to the further contents of the order of blacklisting, submits that the decision was taken that the decision of blacklisting was taken on mere supposition that in the past the developments which have taken place gave an impression to the department that there is not going to be any smooth transition if the impaneled agency is changed. The petitioner therefore questions the correctness of this reason as a ground for blacklisting the petitioner. Assuming but not admitting, assuming that it was difficult for the impaneled agency, / petitioner to continue with the arrangement with Kionics and the government for this project, which led to declaration of the intention of the petitioner to walk out of the agreement, blacklisting would prevent the petitioner from entering into any contract with the government. In that case, the viewpoint of the petitioner ought to have been taken into account, considered, and then only decision was to be taken. The further ground of assail is that there was no direct agreement between the petitioner and the government, as the petitioner was only working as an impaneled agency, though approved by the government, but under the master service agreement between the main vendor / Kionics and the department of the government. The inefficiency of the impaneled agency could be a ground for terminating the contract with the main vendor, or perhaps blacklisting the tender if the situation so demanded, but not with the impaneled agency, who was only working under an agreement with the main vendor. The Land Council for the state, however, has submitted that such technical view of the contents of the notice may not be insisted upon. The government, the department of the government, which had selected Kionics for total solutions, ought to have freedom of terminating the contract if the services provided are not to the satisfaction of the department. Several sets of notices were served upon the vendor and the impanel agency, but the solutions to the problems pointed out were not provided, forcing the government, forcing the department to give a final notice to the vendor as also the impanel agency to improve upon its working, or else suffer termination of contract and eventual blacklisting. True it is, Mr. Vikas Kumar argues that before a blacklisting a notice has to be given, but there is no requirement under law to segregate notices with different fallouts, namely termination of contract, debarment, tentative blacklisting, provisional blacklisting, and blacklisting for a specified term. The petitioner cannot clamor for lack of notice. Stop. Even if the notice referred to above did not qualify strictly to be called a notice for blacklisting, neither the vendor nor the petitioner replied to the same, and in a most unbusinesslike approach walked out of the agreement by giving only a 24-hour notice, especially when the servers were down and the IMS and call centers were rendered totally dysfunctional. After having heard the learned counsel for the parties, we find that the services we find that the services provided by the vendor through the agency of the petitioner as an impaneled agency was not to the satisfaction of the department, but blacklisting in a general manner, but blacklisting the impaneled agency / the petitioner on grounds which were not even confronted to the petitioner would not be justifiable, regardless of the proposition of law that a party to a contract in such business venture ought to have some freedom in getting the work executed and evaluating the quality of work for it to continue with or later perhaps repeat such agreement with the agency / petitioner. It is now well settled that an order of blacklisting, even it be for a limited period, creates a disability and for saddling a company with the aforesaid disability, there should be an objective satisfaction of the authority passing such order. in Eurasian Equipment and Chemicals Limited versus State of West Bengal, 1975, 1 SCC 70. It was conclusively held that in the event of a decision by the state or its instrumentality not to deal with an entity or enter into any contractual relationship with it, entails serious consequences. The authority of the state to blacklist a company is a necessary concomitant of the executive power of the state to carry on trade or business and making contracts for any purpose. And there is no need of any statutory grant of such power. But there is an inherent limitation which is of fairness and rationality in the decision. But may also refer to Patel Engineering Limited versus Union of India, 2012, 11 SCC 257, semicolon, Kulja Industries Limited versus BSNL, 2014, 14 SCC 731, Southern Painters versus Fertilizers and Chemicals, Travancore Limited, 1994, supplementary, bracket 2 SCC 699. BSN Joshi and Sons Limited versus Nair Coal Services Limited, 2006, 11 SCC 548. Bracket close. On a perusal of the show cause note, on a perusal of so-called notice and the final order of termination, we find that the notice was not complete in itself, did not intimate the noticee about the positive displeasure of the department regarding the work up till now carried out and the intention to blacklist the petitioner if the explanation were not found to be plausible or satisfactory. The entire spectrum of the notice was towards the displeasure at poor management of IEMS and call centers and an invocation to the vendor and the empaneled agency, bracket one, that's the petitioner, to improve upon the same. There was no final conclusion of the department that the services rendered by the vendor with the agency of the petitioner was unsatisfactory, not of the standard, and not in tune with the requirements under the master service agreement. This cannot be held to be a proper notice for the petitioner to respond. The later developments in the working of the project, which were never confronted to the petitioner, could not have been grounds, could not have weighed with the department for taking a decision of blacklisting for 3 months. For 3 years. For 3 years. The argument of the learned counsel for the petitioner that there was no agreement with the government in a direct way is of no consequence, is not worth acceptance, it cannot be accepted, cannot be accepted, as under the master service agreement it was approved by one of the parties, that is the department, that the petitioner shall be the impaneled agency of the main vendor, and that all solution had to be given by the impaneled agency.
Your Lordship, it's nowhere mentioned in MSA that petitioner will be party to this.
Even if it is not, even if it was not entered in the master service agreement that the petitioner shall only be the impaneled agency, that the petitioner worked with the department towards the implementation of the project, it definitely provides relevant information to the state, to the department, about the functioning of the impaneled agency and its own decision its own satisfaction whether such agency can in future be entrusted with any task. It may not be necessary for a party to an agreement only to be subjected to blacklisting or to be put on holiday list. It is the satisfaction of the department and its autonomy even in business matters to select only the best, and if the performance of the company, performance of an agency is not found to be satisfactory, such blacklisting can be directed as an order of blacklisting may be adversely affecting a particular agency / party, but it is also a list for the state / department to be aware of that in the past working with such agency had not been to its satisfaction, and therefore not to deal with such agency in near future. So be that as it may, this order of blacklisting does not appear to have, this order of blacklisting therefore does not appear to have, this order of blacklisting does not appear to be in conformity with the legal requirement of such order having been passed after an opportunity, after a reasonable, after the petitioner was noticed with clarity and had an opportunity to represent his cause. For the aforementioned reason alone, we set aside the order of blacklisting for 3 years against the petitioner, regardless of the fact that the services offered by the petitioner were not at all to the satisfaction of the department, and direct that after giving a fresh notice to the petitioner and adverting to the reply which would be given by the petitioner, a fresh decision shall be taken by the department regarding blacklisting. So the entire exercise be concluded within a period of 3 months, to be counted from the date of production of a copy of this order before the concerned department.
So, Lordship, the entire system was checked by the department and they have issued a certificate for that also.
I don't know what you are arguing. What the court has ordered, what you are arguing, mushkil hai. We are on the limited issue of blacklisting and your petition has been allowed. What else do you want from us?
Obliged.